Good morning everyone. This is Ishanja and today we'll be discussing about Article 21 of Indian Constitution. First I'll introduce myself. My name is Ishanja and I do hold a master's degree in Constitutional and Administrative Law from very prestigious Symbiosis Law School Pune, and we'll be focusing only and on Article 21 of Indian Constitution because it is very well considered as a lifeline of Indian Constitution. Apart from Article 32, which is also very important, and it can also be said as an actual lifeline of Indian Constitution. Article 21 provide for essence of Indian Constitution, and it does protect the fundamental rights of Indian citizens in a various possible way. And an extensive research has been done while framing the Constitution and to keep in mind about Article 21. Though over the period of time, due to judicial activism, we can see that ambit of Article 21 exceeded the limits set by the Constitution of India, but it does not move apart from the barrier set by the constituent leaders. So, if we look into Article 21, we'll see that it is a two-line definition which has been given in our Constitution, which says protection of life and liberty, which further says that no person shall be denied life and personal liberty apart from the procedure established by law. So, if we'll again focus on the definition which has been given in the Indian Constitution, we'll see that we come up with two major questions, which is first, what is the procedure established by law, and second is what is life and personal liberty mean. And there are various sub questions which follows these two basic questions. So in order to successfully grab the knowledge about Article 21, we first need to know what is procedure established by law, and how does that affect the interpretation of law. So procedure established by law is that when a law has been passed through the actual procedure which has been given in the Constitution. So as we very well know about the lawmaking process in India, and we can brag about the possibilities of how world should learn from us, but we can also keep in mind that there are circumstances when the procedure established by law can easily be taken over by the majority in the house, and it can be driven by the political agendas of the leaders which we are choosing. Supposedly, in cases of Article 370, which has recently been removed from Indian Constitution, some parts of it has been removed from Indian Constitution, we can see that Article 370 has been moved due to the political majority which has been attained in the House. Now we'll not go into the detail of Article 370, whether the removal of certain part of Article 370 poses a threat to the Constitution, or to the what is the effect of removal of 370 on the socio-economic factor or social factors of people of Kashmir, Jammu and Kashmir. But we can very well come up with the fact that it can very well be done through the political majority. What happens in certain cases that the new laws or certain laws which are already existing in our society can be changed, amended, or revoked, or brought back due to the political majority. So if we cannot say that it's the foolproof way of making a law. So earlier what happened is that our courts, which is High Court and Supreme Court, which basically deals with these constitutional matters, used to only consider the procedure established by law. But as we'll move further in the video, we'll see how the scenario changed over the period of time. So in order to know the procedure established by law and judicial activism which took place in Article 21, we need to know the due process of law. So due process is another way of looking at the law, and it can be traced back to the American Constitution. So we also very well note a fact that our Constitution took certain excerpt from foreign constitution to make it a mixture of all the good features from other constitutions around the world. and one such process is due process of law. So due process of law runs a law through a test of fair and arbitrary. So what happens is, when we look into a certain law, we'll have to look whether it is uh, arbitrary and fair. In order to look into whether a law is arbitrary and fair, there are certain tests. There are certain tests which ranges from natural justice to various different tests, and the formula has been set up in different parts of world, and even our Supreme Court, to the way of judicial activism, has took upon the stance to interpret the law in such a way that a maximum reach of justice can be attained. Because as far as the Indian Constitution and apex court is concerned, justice delivery is the basic concept which we are moved towards. So due process of law, what happens is it gives an scope to the court to interpret in such a way that delivery of justice can be granted to the maximum people. If we'll now, as we gradually move forward with the video, we'll see how court played an important role in expansion of the ambit of Article 21 for general public of India. And in order to know that, we'll have to know that there are certain ways in which court takes over matter, and which has been very well provided in Article 32 and 226 of Indian Constitution. Apart from that, we can also say that law passed by the Supreme Court can be binding across India and has same power as of that passed by the legislature, which has also been provided in Article 141 of Indian Constitution. 141, when mixed with 129 of Indian Constitution, as we'll move forward, we'll study that it makes in Supreme Court an apex law making body, and it can be very well give power to Supreme Court to amend laws in such a way that maximum justice delivery can be attained. So in order to know the judicial activism which happened in Article 21, we'll have to go back to 1950, which is a very important case law in Article 21. The case law of A.K. Gopalan versus State of Madras, which happened in 1950. As we'll see that A.K. Gopalan was a communist leader in Madras, and he has been detained under Preventive Detention Act of 1950. So what happened is that when he was detained by the authorities, he approached the court under certain certain laws provided under Constitution, stating that his civil liberties were hampered while his detention was taking place. So further, what happened that Supreme Court studied the case of A.K. Gopalan and came up with the fact that the arrest of A.K. Gopalan did not affect the civil liberties of the individual, because he was arrested and detained under the procedure established by law. So now if we link back, we saw that the definition of Article 21 itself, that no person shall be denied life and personal liberty apart from the procedure established by law. So here the court was very much literal on the interpretation of the law, and it said that since the this Preventive Detention Act 1950 was somehow fitting the criteria of procedure established by law, therefore the A.K. Gopalan cannot say that his right to life and personal liberty has been hampered in such case. Then comes a very important case, which again has a political connection, which happened right after the emergency of 1975, is Maneka Gandhi versus Union of India of the case came in 1978. So what happened in Maneka Gandhi case, that her passport, when she was leaving the country, her passport was seized under Passport Act of 1967. So under Section 10 subclause 3 of Passport Act 1967, her passport was seized by the authorities at the airport, and she was not given a proper explanation about why the certain act has been done towards her, and why her passport has been seized by the authority, and why she is not able to leave the country. So in order to uh, get certain answer, Menika Gandhi approached Supreme Court under Article 32 of Indian Constitution, as discussed under as discussed previously. Article 32 poses an important part in judicial activism and expansion of Article 21. So what happened is, when Menika Gandhi approached Supreme Court of India, a seven-judge constitutional bench was set up. So a seven-judge constitutional bench was set up to look into the cases, and they came in onto the conclusion that the way in which the passport has been seized by the authorities to prevent Menika Gandhi from leaving the country was unjust and unfair, and it cannot be seeing that though the government had a power that they can seize certain passport and documents from the citizen, it cannot be established why is it fair. So then court overruled the judgment which has been given in AK Gopalan case and established a formula of golden triangle. So what court said that in order to make a arrest or detention fair under Article 21, we must look into the factors established under Article 14 and 19 of Indian Constitution, and thus the arrest or any kind of action under Article 21 must justify the aspects of Article 19 and 14, which also is a very well established fundamental right in our Constitution. So when court looked into it, it said that a golden triangle should be formed, and the principle of golden triangle was coined thereafter. So in case if somewhere during the competitive exams, if the question comes where does the golden triangle concept came from, we can very well refer to the Menika Gandhi case where a constitutional bench came up with the idea. So we'll see after Menika Gandhi case what happened is that the ambit of Article 21 keep on expanding and expanding, and now it has covered various aspect of our life. So we have looked into the cases of A.K. Gopalan and Menika Gandhi, that how Supreme Court has further interpreted law in such a way that the ambit of Article 21 has expanded to the different phases of our life. In the recent times, Supreme Court and some of the high courts of India has played an important role in expanding the ambit of Article 21 in our life. Some of the important judgment, if we look towards right to having and dignity in the society, comes from Supreme Court. The first, if we'll important case in recent time, if we look, is 2014 case of occupational health safety versus Union of India. It came in 2014, and this case discussed the status of laborers and the working conditions of labor in which they are working, and if dignity should be maintained during the working hours of daily wage laborers. So it set up certain principle that how daily wage laborers should be treated in the industry, and how the dignity should be maintained at the highest possible level without interfering with the wages and everything. So what happens in when Supreme Court gives a certain judgment, it has to look into the different factors which has been going in the society. So this case can very well be cited as how the Supreme Court has expanded the liberty part of liberty and dignity part of our common citizens, so which have been working as daily wages. Second such important case comes with the Navtej Singh Johar case. Navtej Singh Johar versus Union of India case, we can very well tie it with the National Legal Aid case, which is NALSA versus Union of India. So these two cases pose an important part in removal of and suspension of Article 377 from Section 377 from Indian Penal Code, and and it gave an important way forward to homosexuality and everything. So what happened is Supreme Court ran certain kind of tests and everything, and it said that Section 377 of Indian Penal Code is itself unconstitutional, and it cannot be held that a certain sexuality should be deprived from have enjoying such rights which a normal gender, male or female, is experiencing. So in this came as an very well landmark case against the homosexuality in India, and uh, it has curbed the various laws which has been passed in order to curb the homosexuality in India. So now, if we look into homosexuality status as of now, we'll see that there are certain things which still need to be done, like the property rights of homosexuals or the marriage rights of homosexual and everything. So that is a different topic for some day. Is but as of now, way forward for homosexuals have been made through the ambit of judicial activism and under Article 21, the scope of Article 21. So we can very well also consider that. Moving forward, we will look into Joseph Stein versus Union of India case of 2019, which itself is an important case for removal of Section 497 of Indian Penal Code, which deals with adultery. So it again set up an important aspect about women's dignity in the society. So what happened is in Article 497 is that Article 497 dealt with adultery in a marriage, which said that uh, a husband is eligible to file a case against other man having an extramarital affair with the wife of the first man. So, Supreme Court, while studying this law, came to the fact that Article 497, though not directly, but somehow is making a woman inferior to that of men, and it is somehow establishing the fact that the woman is a married woman is a property of her husband. So, what happened in this case? The Supreme Court right away struck on the law and proved that the married woman is not a property of law, and a certain formulas of trespassing cannot be applied on women just because she is married. She is not a property of law. What happens is, if we look into normal scenario, when someone encroaches on your property, you will go file a case against the other individual. So same was the case with adultery. Though you cannot file against a case against your wife for cheating or adultery, you can very well file a case against the man who she was cheating with, and thus it means that it somehow Supreme Court came up with the formula that and came up with an explanation that in this case what happens is women is considered as a property of an individual man she's married to, and other person encroaching on that uh, was sued in the court of law. So what happened is that it mere subtracted the status of women to a thing or a property which can be for which there can be cases. So therefore Supreme Court came up with the thing that we should move on with the age old concept of women being property of married men, and therefore dignity should be provided to women and the choices she makes in life. So this can again be a very well case if we look into somewhere during the course of competition, if the case that how the judicial activism has increased the ambit of the Indian Constitution, we can very well refer to Joseph Stein versus Union of India case. Apart from Navtej Singh Johar India versus Union of India case, then there is Nalsa case, Nalsa versus Union of India case. So all these cases can be considered while making an answer for judicial activism and the rights provided under Article 21. If we move forward with the ambit of Indian Constitution, we'll come forward with many other such cases which we'll further discuss in this video as we'll move forward. So Supreme Court, what happened is apart from giving these landmark judgment, started stabilizing Article 21 as the basic lifeline of Indian Constitution, and through case laws definitely, because Supreme Court does not hold powers to make law apart from setting the judgments under Article 141, which is applied to whole of the India. So till now we have looked into the fact that how Supreme Court has established the ambit of right to life and personal liberty to the greatest level possible. But Supreme Court did not stop there. Uh, we have till now looked into some of the recent judgment along with some of the judgment dating back as of 1950. But Supreme Court then thought that the ambit can very well be expanded much further in order to provide the maximum justice and social uh, security to large number of public. So then Supreme Court made some of the important judgment in the right to livelihood, which we can say is an important part of right to life and personal liberty. So what happened in 1986? There came a case of Olga Tilis versus Bombay Municipal Corporation, which is BMC. BMC again is one of the wealthiest municipal corporation in whole of the southern Asia. So what happened in Olga Tilis case was there was a certain slum dweller who were capturing the areas and were living under the Bombay Municipal Corporation jurisdiction. So BMC came up with an idea to remove the encroachment which has been done by the public in that particular slum area, but the different sections of the society from that slum approached the court, and court further said that though there is a case of proper trespassing, and the person residing in that slum is definitely encroaching on the government land which has been there for a long period of time, but they can definitely not be moved without considering certain factors. So what happened was that when people approached the court at that time, the monsoon was going on in Maharashtra, and court first of all ordered BMC that any action should not be taken till that time of monsoon, and they should wait till the monsoon in order to take the action forward. But then the Supreme Court also said that what happens is that though they are encroaching the government area, we should not always look into the negative side. Rather, we should also diagnose the problem and look into the factor that why this is happening. So this was happening because there were certain livelihood issues going on with the slum, and they needed a place to live. So then Supreme Court referred to 1976 census and passed the judgment that anyone who has been living on the particular land before 1976 should be provided a resettlement right by the government of Maharashtra, and they should be resettled in such places where livelihood and dignity should be maintained in the highest order. And thus the Supreme Court passed a very important case here. Secondly, so till now we have looked at Supreme Court has interpreted the law in Menka Gandhi case. We have looked how Supreme Court through Article 21 has established the dignity of women, daily wage workers, life. The Supreme Court moved into 377 and abrogated it, and then we'll further see that Supreme Court also played an important role in health and healthcare through Article 21. So this came in cases of Permanent Katra versus Union of India. It came in 1989. So what happened earlier was there were certain cases where medical treatment to a patient was delayed due to some of the legal procedure. So, but then Supreme Court came up with a case that, and it said that whatsoever will the case or any legal formalities remaining, the medical treatment should be given then and there without being waiting for the legal process which uh, should take place. There is an important Bollywood scene, if you guys could relate, is in Munna Bhai MBBS, when there was a patient waiting and doctors asked to fill the form. So we can very well relate it to Pawan Katara case of versus Union of India case. That in that case, Supreme Court very well said that we should not wait for any such forms or legal formalities to take place, and rather treatment should be the highest. Uh, Treatment should be given as then and there, and we should definitely try saving our life rather than looking into legal procedure and other. So we have seen right to life and dignity part very well till here, but we also now know that Supreme Court says that right to life also includes right to live, right to die with the dignity. Now, in order to know that, we must also acknowledge the fact that euthanasia's judgment has gone through a grilling process over the period of time, for the longest period of time in Indian legal history. And it dates back to 1994 when P. Rathiraman versus Union of India was filed, saying that Section 309 of Indian Penal Code was violative of the principle of Article 21, and thus Supreme Court said that a forced life should not be given, forced life should not be considered, and a right to life should be provided, and they struck down Section 309 of Indian Constitution, saying that it is void and it is against the principle established by Article 21 of Indian Constitution. But then came the Gyankor versus State of Punjab case, which is a very famous case of 1996. What happened in Gyankor case was that Supreme Court says that right to life and right to die is very well and part of Article 21, though right to die is against the basic principle of Indian Constitution, which is right to life, and thus it overruled the case of earlier case of P. Rathiraman versus Union of India, and said that the concept of right to die is against the concept of right to life of Indian Constitution. So moving forward, we'll see that after the Gyankor case came the Aruna Sonbok case, which was an 2011 case. 2011 case, what happened that Supreme Court said that in certain cases related to euthanasia, euthanasia can be allowed on consultation with the doctors. Because in certain cases it's better that a patient or the citizen should be relieved of his life in order to die with the dignity, and they should not be continued so that the a further pain could be avoided in certain cases. Aruna Sonbok was a landmark case is because since we already know that Gyankor case has overruled the previous case. Then came the final case of common cause, which was a registered society versus Union of India, which clearly in which Supreme Court suggested that right to life also contained right to die with the dignity, and in order to right to die with the dignity, cases of euthanasia should be allowed, and certain parts of Section 309 was struck down, and thus a new definition was included in Article 21, which now also included right to die. Moving forward, we'll see that the Supreme Court gave various other judgment in cases of right to privacy also. First of which started with 1997 cases of PUCL versus Union of India, which is Public Union Civil Liberties versus Union of India case, in which Supreme Court very well established the fact that tapping of telephones should be declared unconstitutional and should not be carried on unless a procedure established or the reason provided by the law. Uh, because at that certain point of time, what happened was there were different cases of telephone tapping, and various of the leader through POCL approached the court, and the court had to make the judgment. Uh, Again, one such medico-legal case which came was Sujit Singh Thind versus Kalamjit Kaur, which was a 2003 case, where Supreme Court said that right to privacy has been infringed in cases of virginity test which has been done on the girls, and thus it should be stopped right there and there. We can see that this case also played an important role in stabilizing some of the principle in the amendment of rape laws which came after Nirbhaya case. So then a very important case for competitive exam and in general for students of law was Justice Puttaswamy and another versus Union of India case, which is a 2019 case, and which is very well known as the Aadhaar case. So it also came to the Supreme Court, and Supreme Court said that though Aadhaar is a good concept, and the act passed for the Aadhaar is up to the mark with the privacy law, there are certain sections of the act which was not in line with the privacy law, and thus those sections of the particular law were struck down, keeping in mind the privacy issues. And Supreme Court very well gave an fitting reply to the government, and they established a highest possible benchmark for privacy in India. Supreme Court did not stop there. We have till now seen that Supreme Court had given judgment about privacy, right to die with dignity, right to livelihood, and many other things as we have discussed earlier in the video. But now Supreme Court wanted it to expand further, and so in 1992 cases of Mohini Chen versus State of Karnataka, Supreme Court came up with the idea of right to education and made right to an education as a fundamental right under Article 21 of Indian Constitution. So Supreme Court said that everyone is entitled to get free education from government, and right to education is a fundamental right, which itself is a very unique and path-breaking case law as far as education is concerned in India. But then in cases of Unni Krishna versus State of Andhra Pradesh in 1993, Supreme Court curtailed itself and said that any child who is up to the age of 14 is only entitled to get right to education, and anyone beyond 14 is not entitled to get free education unless state's economic power suggests so that it can continue with the education of a particular child, which gave a bit of relief to state governments across India. Then this has been further amended and kept into the constitution, and as we today know that Article 21 also considers right to education. So the roots go back to these two judgments of Unni Krishnan and Mohini Jain. So Mohini Jain was definitely the first case, and particular competitive exam do ask separate question related to right to education, so we can very well refer to these two cases. One such strange case which happened with Article 21 was right to sleep case. Right to sleep, we have discussed about various rights, and we know how the Article 21 facilitated from the same. But a very strange law is right to sleep, which has also been discussed in Supreme Court. So what happened is, it's a 2014 case of Ramlila Maidan versus Home Secretary, Union of India case. So what happened at particular time, Baba Ramdev, who is a yoga instructor in India, he was having a yoga program in Ramlila Maidan, Delhi, but somehow it turned into a protest against black money and everything about the corruption in the ongoing government, 2014 UPA government. So this continued till 12:30 or 1 at the night, and everyone was sleeping. Then came CRPF, Delhi police, and everyone, and they started beating up the protesters and used tear gas and everything. So after that, uh, the protesters approached Supreme Court, and Supreme Court said that right to sleep is also an important right under Article 21, and there are there are cases where just the sleep of an individual cannot be disturbed by any authorities unless a reasonable explanation can be given on that, and therefore this should be considered as a serious offense and a violation of human right. So we can very well see that now the Article 21 embed just now cover each and every aspect of life, and this is not the end. There are various other cases where Supreme Court has established different small and uh, important principles about right to life and liberty and dignity and everything, and which can be traced back to Supreme Court judgments definitely, and it does take a long time to cover the aspects of Article 21, and can only be covered in detail through extensive reading and practice. Thank you.